Let us turn to a discussion of evidence. An indictment is not evidence. It merely describes the charges made against the defendant. It is an accusation. It may not be considered by you as any evidence of the guilt of the defendant. In reaching your determination of whether the government has proved the defendant's guilt beyond a reasonable doubt, you may consider only the evidence introduced or the lack of evidence. Let me emphasize that a lawyer's question is not evidence. You should also not give any consideration to the fact that the attorneys on each side may have objected to certain questions being asked or to certain evidence being received. Any evidence as to which any objection was sustained and any answer ordered stricken must be disregarded in its entirety. It is the duty of the attorney for each side of a case to object when the other side offers testimony or evidence which the attorney believes is not properly admissible. Counsel also have the right and duty to ask the court to make rulings of law and request conferences at the sidebar out of the hearing of the jury. All those questions of law must be decided by me, the court. You should not show any prejudice against any attorney or his client because the attorney objected to the admissibility of evidence or asked for a conference out of the hearing of the jury or asked the court for a ruling on the law. It is irrelevant whether you like a lawyer or whether you believe I like a lawyer. The issue before you is not which attorney is more likable or the better attorney. The issue is whether or not the government has sustained its burden of proof. As I already indicated, my rulings on the admissibility of evidence do not indicate any opinion about the weight or effect of such evidence. You are the sole judges of the credibility of all witnesses and the weight and effect of all evidence. There are two types of evidence which you may properly use in deciding whether the defendant is guilty or not. One type of evidence is called direct evidence. Direct evidence is where a witness testifies to what he saw, heard, or observed. In other words, when a witness testifies about what is known to him of his own knowledge by virtue of his own senses, what he feels, sees, touches, or hears, that is called direct evidence. Circumstantial evidence is evidence which tends to prove a disputed fact by proof of other facts. There is a simple example of circumstantial evidence, which is of the news in this courthouse. Assume that when you came into the courthouse this morning, the sun was shining and it was a nice day. Assume that the courtroom was without windows, as is this courtroom, and you could not look outside. As you were sitting here, someone walked in with an umbrella which was dripping wet. Someone else then walked in with a raincoat which was also dripping wet. Now, you cannot look outside of the courtroom, and you cannot see whether or not it is raining, so you have no direct evidence of that fact. But on the combination of facts which I have asked you to assume, it would be reasonable and logical for you to conclude that it had been raining. That is all there is to circumstantial evidence. You infer on the basis of reason and experience and common sense from an established fact the existence or the non-existence of some other fact. The evidence in this case consists of sworn testimony of the witnesses and the exhibits received in evidence. Turning to the subject of exhibits that have been marked for identification but have not been received in evidence, however, may not be considered by you as evidence. You should consider the evidence in light of your own common sense and experience, and you may draw reasonable inferences from the evidence. Anything you may have seen or heard about this case outside the courtroom is not evidence and must be entirely disregarded. You had the opportunity to observe all of the witnesses. It is now your job to decide how believable each witness was in his or her testimony. As jurors, you are the sole judges of the credibility of each witness and of the importance of his or her testimony. It must be clear to you by now that you are being called upon to resolve various factual issues in the face of the different pictures painted by the attorneys which cannot be reconciled. You will now have to decide where the truth lies, and an important part of that decision will involve making judgments about the testimony of the witnesses you have listened to and observed. Your decision whether or not to believe a witness may depend on how that witness impressed you. Was the witness candid, frank, and forthright, or did the witness seem as if he or she were hiding something, being evasive, or suspect in some way? How did the witness testify on direct examination compare with how the witness testified on cross-examination? Was the witness consistent in his testimony, or did he contradict himself? Did the witness appear to know what he or she was talking about, and did the witness strike you as someone who was trying to report his or her knowledge accurately? How much you choose to believe a witness may be influenced by the witness's bias. Does the witness have a relationship with the government or the defendant which may affect how he or she testified? Does the witness have some incentive, loyalty, or motive that might cause him or her to shade the truth, or does the witness have some bias, prejudice, or hostility that may have caused the witness, consciously or not, to give you something other than a complete accurate account of the facts he or she testified to.